So who do I have from MDOC this morning? Mr. Bomarito?
Yes.
Good morning. So your attorney usually goes to the other courtroom first. So she'll be with us shortly, okay?
Okay.
All right, thank you.
Thank you.
Mr. Moore, Mr. Likens was picked up last night, so we'll be doing that. They're tracking that down, or they already did. I don't know, one of the two. I have somebody who's logged in with an iPhone, and can I have your name?
Yep, Sarah Sinclair.
Okay. Thank you. Are you going to wish to speak today? I did read your victim impact statement.
Yeah, I didn't want to submit a victim impact statement. I just want to speak on behalf of getting the no contact removed.
Yep. Okay, thank you. Hold on, we'll give you just a moment.
Thank you. Okay, thank you.
All right. So, Ms. Zoki, your client is now in the Zoom room. So we're ready. In the matter of the people of the state of Michigan versus Matthew Richard Sinclair, we have two files, 25-22245FH and 25-22246FH. This is the date and time set for sentencing in this matter. I have Carly Zoki appearing on behalf of the defendant. What's your P number?
Yes, 79061.
All right. Mr. Sinclair is appearing via Zoom, and I also have joining us Sarah Sinclair. I did receive a victim impact statement from her. Have you received that as well?
I'm not certain I did from Sarah. There was a victim impact statement in 2522246. I believe that I did receive the victim impact statement in that case. And I believe that victim is in the courtroom and planning to make a statement as well.
So, okay. So, this, I have it here. So, I need a copy. Miss Adams, could you come get a copy of this for Miss Zoki? Bear with us while we get that, and then if you need a breakout room with your client, you can either go in back or use the hallway. Okay.
Briefly, thank you.
All right. Mr. Muwad, I do have your client as well.
Judge, did Miss St. Clair ever get, do we know where she's at all, or is it just Mr. Wainscott that you have? If you know.
Say that again.
Well, is it Kate? Go ahead.
You're appearing on behalf of Wainscott, correct?
Right. We had Caitlin Manners, the co-defendant too. She went up to the inpatient program up north and left it. I don't know if you guys have her in a warrant status or she was set for today too. Sorry, Judge.
Okay.
Mr. Watt, it is in warrant status. She never contacted me after she left treatment.
Okay, so we just have Mr. Wainscott.
Correct,
Okay.
and he's
I'll
doing
call
well.
that one then. In the matter of the people of the state of Michigan versus Caitlin Marie Maynor, file number 25-21933FH and 24-22088FH. I have Elias Mawad appearing on behalf of Miss Maynor. She is currently in warrant status. We've not heard from her. She's not in the courtroom, I don't think. So she's not looking like she's in the courtroom. So we'll leave that matter. Will remain in warrant status. All right. So then I do, are you gonna need a breakout room?
I'm not. This is the victim impact statement.
Okay.
I have received.
All right. Do you mind if I take Mr. Mawad because he's loitering outside of some courthouse somewhere? And I'm sure there's a meaner judge than me waiting for him.
Lovely Monroe County, Judge.
Oh, they're all nice there, so.
Yeah, they are.
Mr. Wayne Scott, go ahead and unmute your device and start your audio. Is there anybody here that's a victim in this matter who wishes to speak? Anybody? No? Okay. Mr. Wayne Scott, if you could start your video and unmute your device. And, okay.
All right.
All right, can you hear me now, Mr. Wayne Scott? Mr. Wayne Scott, can you hear me? I can hear him. So I'm going to send a chat to him to maybe turn up his audio. Or his
Ben, can you
volume.
hear us?
He's connected to audio, so I just sent him a chat to turn up your volume. Sending another chat, we can hear you, but you seem to be unable to hear us.
Is this talking to me or this Wayne Scott? Or no?
There we go.
Mr. Wayne Scott, can you hear
Yeah, there we
me?
go. Yes, ma'am.
Okay, all right, so, right, all right, in the matter of the people of the state of Michigan versus Benjamin Wayne Scott, 24-21932FH and 24-22089FH. Elias Mawad appearing on behalf of Mr. Wayne Scott. I do not appear to have anybody here to make a victim impact statement or a statement to the court. I do have Darren Coast from Pretrial Services. He has provided a letter dated June 26th of 2025. Mr. Wayne Scott is still at Hope House in Jonesville and is doing very well. He appears to be taking the program and his sobriety very seriously. So let me get this up. All right, Mr. Wayne Scott, have you had an opportunity to read and review the pre-sentence report?
Yes, ma'am.
Have you had an opportunity to discuss that with your attorney?
Yes, ma'am.
Are you satisfied with Mr. Mawad as your attorney and the advice that he has given you?
Yes, ma'am.
All right, Mr. Mawad, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor, very accurate, very thorough. Thank you.
Thank you. Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defects?
No, Your Honor.
The probation department in this matter computed the sentencing guidelines on 24-21932FH, count 1, breaking and entering a building with intent to be 29 to 57 months. And on file number 24-22089FH, count 1, larceny in a building to be 7 to 23 months in jail. So also, do you agree with that computation of guidelines?
I do, Judge. Yes.
All right, so there is a sentencing agreement, Mr. Wad, that he can receive up to 1 year in jail plus probation and restitution. I don't have Miss Holly, but I do have Mr. Moore here today. And obviously that was up to 1 year. He's currently in treatment, so the court will of course take that into consideration. Before the court passes sentence, do you wish to say anything on behalf of your client?
Well, you know, Judge, this was a really good deal struck with Mr. Hartung and I know that Ben knows it. But I want Ben to know that I talked to his father 2 weeks ago. His father was crying. This is his son. He doesn't want him to be an addict. And he doesn't know that I've been talking to his father, but his father's a good guy. And, you know, Ben, during this, the bond on all this, and even after the deal was cut, you know, he went back to doing it. I just want him to be a stronger person, and I want him to get the treatment, and I want him to take care of his dad. And I hope he does well. He got a hell of a deal here, Judge. And whatever you decide to do is fine. But I want him to know that you got to take care of your dad too. He's at the age now. You got to watch out for him and stay clean. Other than that, Judge, I'm ready for sentencing. The court knows the history of this case.
All right, Mr. Wainscott, is there anything you'd like to say on your own behalf?
I'm definitely, it's the first time I've been in rehab, and I'm definitely, I'm mad at myself that it took this long, that it really took all these years to say that I can do this, and I'm excelling. I'm kind of like the group leader here, and I'm taking over all the classes and stuff, and I'm helping all the young guys coming in, and I'm using myself as an example. I'm like, do you want to be like me? Do you want to be 49 years old? Or, you guys got a chance. And I've been trying to do everything I can to help out around here as much as possible. And I've been here, I'm clean for 45 days. And that's the first time I've been able to say that in a very long time. I mean, probably 15 years. So I'm here, and I'm definitely I'm gonna make it. I know I'm gonna make it. And I've actually gone to the dentist, and I got my health back on track. My cholesterol's coming down. Everything is starting to work out for me, and that's all I really got to say, Your Honor.
Okay. All right, anything else to, oh, go ahead, Mr. Wainscott, I'm sorry.
That was it. I'll start babbling, and then I'll turn into something else. I'm just happy I'm here, and I'm realizing I'm mad at myself that it took this long to get like this. And it wasn't hard getting sober. I'm mad at myself for that. But what's really crazy is I'm learning all these new coping skills and boundaries, and so much to recovery that I never really had a chance before, because I never really thought it was that deep. I'm dealing with a lot of issues. I'm in sessions 8 to 10 hours a day, and I'm learning who I am again. So. That's it, Your Honor. Thank you.
Thank you. Mr. Coast, any other updates from you?
I don't judge. I mean, he's doing a great job. I mean, yeah, I commend him on his efforts.
All right, thank you. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. It's a sentence of the court that you will be placed on probation on each file for a period of 36 months. On file number 24-21932FH, I'm going to now listen, 1 year in jail suspended. I'm going to suspend that 1 year in jail, which requires you to complete the program you're in successfully to get out report. If you violate probation, you're looking at a year in jail. Do you understand that?
Yes, ma'am.
On that file, there will be $130 crime victim rights fee, $68 in state costs, a supervision fee of $30 per month, $60 if we need to put a tether on you, and $750 in court costs. I will give you credit for 2 days in the Lenawee County Jail you've already received. So understand this is a downward departure based on a Killebrew agreement that was struck between the prosecutor's office and your attorney. Your guidelines call for a minimum of a 29-month prison term. Do you understand that?
Yes, ma'am.
Okay, and you are 49 years old, so it is time to take responsibility for your life. Now, on file number 24-22089F, I will give you 36 months probation. You have no credit for any time served on that file. There is a $68, let me see here. Okay, so there's restitution in the amount of $10,700, which I believe is half of the total restoration amount or restitution amount. Is that correct, Mr. Mawad? Yes. So, the actual restitution looks like it's $21,400 and you're joint severally liable for that. But your amount is $10,700. So as soon as you get out of rehab, you need to get a couple jobs to start paying on this. On that file, there's $130 crime victim rights fee, $68 in state costs. I already ordered the supervision fee on the other file, so I won't order it on this file. And I already ordered court costs on the other file, so I won't assign those to this file. You are to have no contact with Kelly Moe and or Caitlin Maynor. If she reaches out to you and wants help, direct her to Mr. Mawad. But do not get involved with people who are gonna bring you back down. Do you understand that, Mr. Wayne Scott?
Yes, ma'am.
I realize she may or may not be pregnant with your child. I don't know, but that also means until you have permission of the court, you have no contact with her. Do you understand that?
Yes, ma'am.
Okay. And you must obey and comply with all the articles of your probation, which means no alcohol, no controlled substances, can't be anywhere there's alcohol or controlled substances. You're gonna be required to get a job. Your restitution's pretty high, you better get two. You're gonna be required to do assessments and treatment. They have the right to search your house and your property if they have reasonable cause to believe you have items which will violate your probation, and any other terms of probation. Now, Mr. Wayne Scott, we'll get an address from Mr. Mawad, but Mr. Moore, because he's in an inpatient program, how do we have him set up to meet with you?
First, I go, what program is he in?
I can't hear you, Mr. Moore.
He's at the Hope House. Tom was asking what program is he in? He's at the Hope House.
And what's it, do you have an out date, Ben?
Yeah, they're saying it's, it was August 8th, I believe, but it's all per how I'm doing. I might actually, they're saying I might leave early. I've completed everything and I'm doing better than everyone else, I guess. So.
All right, listen up. You will come see Agent Holly upon your release, but if you're released on the weekend, you'll come the following business day. So you also have her number. Make sure that you communicate and sign a release so that they will communicate with her.
Okay.
And then, Mr. Wayne Scott, we're gonna mail the Hope House for each file 3 copies of your notice of right to appellate review. We need you, we'll mark 1 copy for each file for you to initial and date. We need you to initial and date those copies. I'll also send a self-addressed stamped envelope. Put those 2 initial and dated copies into the envelope and mail it back to us. The other 2 copies for each file are for you. If you wish to appeal your sentence, you would fill out the forms and mail them to the address listed on the form within 42 days. If for some reason you haven't received those in the next 30 days, call Mr. Mawad and he'll make sure that we mark that you wish to appeal your sentence. All right?
Absolutely. Thank you.
Okay, those probation terms start now. Make sure you stay in contact with Ms. Holly and sign any waivers so she can get information about you there. All right?
Okay. Should I call her today then?
Maybe next week. Mr. Moore, call Ms. Holly next week.
Yeah, you could call her on Tuesday and give her an update and make sure that she has some counselor's name or somebody she can speak with.
Oh, okay, absolutely.
All right, very good. Anything else, Mr. Mawad?
Well, I just want to let Ben know that, you know, your father's at that age where the kid should be taking care of the parent, not vice versa. So keep doing what you're doing, but also take care of your dad. He literally was crying regarding you. All right. And he's a good dude. Okay.
Yes, sir.
All right. Thank you, Judge. Thank you,
All right,
everybody.
excellent. Thank you.
Okay.
Thank you.
Miss Sophie, now we can. Mr. McCready, on the Matthew Sinclair matter, we do have a victim on Zoom who wishes to speak, so I don't know if the prosecutor or anybody is here for that file. Who is your prosecutor in this?
I believe it was Isaac.
Isaac's name.
Isaac is in the office.
I'm just letting you know there's a victim that's going to speak on that one.
Yeah, I
Okay.
can let him know. Are we ready to do that right now?
Yeah, he can zoom in, it doesn't matter.
Yeah.
All right, so we are back on the record in the matter of the people of the state of Michigan versus Matthew Richard Sinclair. We have two files, 25-22245FH and 25-22246FH. So, Mr. Sinclair, have you had an opportunity to read and review the pre-sentence report?
Yes, Your Honor.
Okay, I'm gonna need you to speak up more so we can hear you. You might be too far away from the microphone, I'm not sure. So can you
Better
repeat
now?
your answer, please?
Yes, Your Honor.
Okay, and have you had an opportunity to discuss the pre-sentence report with your attorney?
Yes, Your Honor.
Are you satisfied with your attorney and the advice that she has given you?
I am, yes.
So Ms. Oki, you've had a chance to discuss the victim impact statement we received?
Yes, Your Honor.
Okay. Ms. Zoki, do you wish to explain or challenge the accuracy or relevancy of anything in the pre-sentence report?
No, not.
Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
No, Your Honor.
Guidelines do not apply to this case because it was pled down to misdemeanors. So, Ms. Sinclair, it's your choice. You can start your video or you can choose not to. I have had an opportunity to read through the victim impact statement. So if you would like to unmute your device, you can go ahead and make a statement. But again, you don't need to turn your video on if you don't want to. All right, but you can. There you go.
That's fine, thank you.
All right.
So yeah, in regards to everything, I would really like the no contact order dropped. I want to be able to go to counseling with my husband. I want to be able to be a family. I want to go to church together. I want to be able to rebuild what we had before things went off the rails. Everything that happened was due to substances. That is not who Matt is. He is a great man. He is a wonderful husband and a good father. And I know that he's been going to counseling and I know that he's been working. And I am so proud of how far he's come. And I'm not excusing anything that he did, but I know that he is in a much better place and I want to be able to move forward with him and my family. And I need him home with me and my boys. And I just want to be able to move forward and heal as a family. And I can't do that without him. So I just really want the no contact order dropped, please.
Okay. Isn't May Reed Carpenter your daughter?
She is married.
Okay. I find it interesting that you did not mention one time the emotional damage and trauma he did to your daughter.
Because I'm not talking on her and him. I'm talking on me and him.
Okay.
And the no contact had nothing to do with her and him, this situation.
All right. Are you gonna help him pay restitution to your daughter?
If I need to.
All right. Mr. Sneed, is there anything you'd like to say on behalf of the people?
No, thank you, Your Honor. And I'm sorry, my camera doesn't seem to be working at the moment.
Okay. All right. Okay. Anything anybody wants to say?
I guess she's not gonna have to help me.
Hold on, Mr. Sinclair, I'm not talking to you right now. All right, are you May Reed?
Yeah.
Mareed? Okay, all right, and so I'm gonna need you to speak loudly because we're recording this, okay? So state your name for me.
My name is Marie Carpenter.
Marie. Okay, go ahead. Say it again, Ms. Spade.
Can I please never spell it?
Spell your first name.
M-A-I-R-E-A-D.
Okay, very good. So you have a statement you'd like to read, so go ahead.
I personally do not think it is safe for him to be around my mom, me, or my siblings. By him, I mean Matthew Sinclair. From laughing at my infant brother falling off of their bed onto a hardwood floor to punching holes in our walls, doors, and shower, He shows a lack of consideration for others and unrestrained anger, drugs or not. He has directly said to me verbatim, "I'm scared your mom might push me too far and I'll kill her." I was 17. I implore you to think about the situation and what would make saying this okay. I had no way out of that situation. I had no way out of that home, and I was in high school. I can't shake this feeling that if he is to relapse, if he is to get too angry, and if something doesn't go his way, he will cause potentially irreparable damages. I understand that he is working to improve himself, but this brings no comfort at all considering the situations we have been through previously as a family and both now. I understand that from my perspective, he is the same Matthew Richard Sinclair that stole from me, that hurt my mom, threatened to hurt her, that made me consider suicide. Drugs or not, I have never gotten a single apology, nor has he ever acknowledged his wrongdoing towards me. Bias aside, I think that he needs true consequences and that he has been let off one too many times. Nobody should ever be in this position, in my position at 19 years old. I should be enjoying my summer break before college, but I am here at court fighting for my rights against someone who was supposed to protect me, someone who is supposed to love me and respect me as a parental figure. I understand he accepted a plea deal. I understand that from the plea deal, he will be charged much less than he deserves. And this is heartbreaking to me, not just for myself, but for my community. What happens when another person does something like this? Would you let him loose to continue causing harm to others by allowing him to practically escape from his crimes that he did to his teenage daughter? It's just as poor as he is. I'm disgusted by the blatant disregard to the harm he has done by himself and by my other family members. Just because he admitted to his crimes does not mean he should be punished any less or regarded as any more. Matthew committed unforgivable crimes against me from the ages of 16 to 19. I was in a position to do nothing to protect myself. And if the court cannot protect me, then who should I hope for? And my message to Matthew is as follows. For over the 4 years, you have hurt me beyond words what can describe. And I hope you live the life you deserve, away from me and my family. I would appreciate being paid back, but no amount of money will take away the pain and distress you caused me and still continue to cause me. I might be able to forgive you eventually, but I will never be able to forget you. You will forever be in my nightmares, and I hope that you never contact me again.
Now, have you worked through financial services to clear up your credit score and reports?
Yes, Your Honor.
Okay, so, okay. And you no longer live with your mom, right?
No, I had to move out when I turned 18.
And you're living somewhere stable now?
Yes.
All right, anything else?
No.
Very good, thank you. Mr. Sneed, anything else?
No.
All right, so Ms. Oki, anything you'd like to say on behalf of your client?
Yes, there is, Your Honor, but Mr. Sinclair would like to make a statement, and I would like him to do that first.
Okay, Mr. Sinclair.
Your Honor and Junior Aid, the easiest thing I can do today.
We're not picking you up, so you need to kind of face the microphone and speak a little bit louder.
Can you hear me now?
Yes, it's better now.
All right, Your Honor and Junior Aid, the easiest thing I could do today would be to stand here and offer excuses, but I'm not here to justify what I did. I'm here to take full responsibility. I accept the consequences of my actions, and I am prepared to see through whatever punishment the court decides. More importantly, I want to speak directly to Mairead, not my own conscience, but because it's the right thing to do. For years, you trusted me, you confided in me, you welcomed me into your life, even saw me as a part of your family. In some ways, as a father figure, I betrayed that trust. I let you down in the worst possible way, and I hurt you deeply. You are a smart, kind, and beautiful young woman. You are a loving sister to all your brothers, even Matthew and Mason, which you've always treated like they were your own flesh and blood, and they all love and admire you more than you know. I understand that what I took from you wasn't just money. I stole your sense of safety, your peace of mind, and your trust in others. And the hardest truth is no amount of money can fully return what I damaged, and that's something that I have to live with. What I did was selfish, deceitful, and wrong, abusive in a way that words alone can't fully express, and for that I offer my deepest and most sincere apology. I'm not asking for your forgiveness. That would be selfish of me. Whether you forgive me or not is entirely up to you, and I would understand if you never do. But I have a responsibility to own what I did, to make amends where I can, and to clean my side of the street. More than anything, Mairead, I hope that you find healing. I hope the damage I caused doesn't define your future. You have your whole life ahead of you, and I pray that this painful chapter does not shape the decisions or dreams that follow. In closing, I want to say that I believe in you. I believe you are strong enough to build a life you're proud of, one that reflects who you are, not what was done to you. And I really, really hope you believe that too. Thank you for listening.
Thank you. Ms. Silky?
Yes, Your Honor. I would note for the court that Mr. Sinclair did do stay in a rehabilitation facility some time ago. He has been working on his sobriety diligently since 2024. He is currently enrolled in counseling for, I think he did the retail fraud class initially, but is working currently in counseling with Sally Welsh to address both substance abuse issues and anger issues. He is working diligently on that. When we spoke last night regarding the sentencing today, he was working on his homework for those sessions. I think he has taken to heart the harm that he's done and very genuinely is remorseful and wants to do what he can to make amends for that situation. He is fully employed and fully intends to work diligently, making consistent payments to go not only to the court, but more importantly to the restitution. And again, I think just he is taking it very seriously and is looking to move forward in a much better path. We understand that there was an agreement for the 365-day suspended sentence. He fully understands what that means, and he does not have many chances left, and that is very much hanging over his head with this sentence. So with that, we would request the court impose the sentence as recommended by the probation department.
Anything else? Second. All right, so Mr. Sinclair, parents or parent figures that are supposed to care for and provide for their children, but instead swindle them and take advantage of them are obviously pretty reprehensible. I understand that there were substance abuse issues going on. So I hope, in fact, you do redeem yourself and you do pay restitution in this matter. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon this record on the record at this hearing. Obviously, there's no guidelines. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. It's sent to the court. You'll be placed on probation for a period of 24 months. I will suspend the jail sentence of 1 year in jail per the Killebrew agreement that was reached. I'm going to order restitution on file number 25-22246FH in the amount of $6,000 to be paid and the amount of $250 a month. You are also to, if there are any costs for services to clear her financial record, in case she needs to hire an attorney or pay for a service to help get rid of the debt that you caused her to incur, that will also be added to restitution. I don't know if that'll happen, but if it does, She does deserve reimbursement for that. On file number 25-22245FH, the domestic violence file, I am going to order the 24 months probation. There is a $100 fine, $50 state costs, and $75 crime victim rights fee. I am going to order that I am going to order a no contact with Miss Carpenter as well as Miss Sinclair. Once Mr. Sinclair has completed his programming with Sally Welsh at Recovery Roads, and Miss Sinclair, you can provide proof that you completed a domestic violence victim class. Then you can petition the court to have contact. Miss Sinclair, the hardest thing for me is when I see people walk in the courtroom and choose someone other than their children. And that's what you've done today. And I'm sorry that you were a victim, and I'm sorry things happen to you, but I think that until you and here in a better place and have received treatment and counseling, that there should be no contact. And like I said, once you've completed those programs, you can request through the probation officer for a contact order. Let's see here. On the domestic violence file, you will complete counseling with Sally Welsh. You will attend 12-step meetings and get a sponsor. You're not to use any alcohol. You're not to use any illegal controlled substances. You're not to engage in any threatening or assaultive behavior. The probation department can search your home for probation purposes at any time, but they also can search your home, your car, your computer, and your personal effects if they have reasonable cause to believe that you have items that violate your terms of probation. If you're in contact with Miss Sinclair, if you are found together, you will do a year in jail. You understand? So on file number 25-22246FH, that's the larceny. That's the file that I ordered the $6,000 in restitution to be paid at the amount of $250 a month, as well as any cost for any services she's required to use to clear her credit report. Let's see. There is a $250 fine, $50 state costs, $750 in court costs, and a $75 crime victim rights fee. And again, the 24 months probation. Same terms of probation will apply. Let's see what else I got in here. I think that's it. Anything else, Mr. Steen?
No, thank you.
Anything else, Ms. Oki?
No, Your Honor, thank you.
So, Mr. Sinclair, we are going to mail to you 3 copies of your notice of right to appellate review on each file. I need you, there'll be 1 copy that's kind of flagged for you to initial and date for each file. And there'll be a self-addressed stamped envelope. I need you to initial and date those 2 copies, 1 for each file, put them in the envelope, mail them back to me. The other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail them back to the address listed on the form within 42 days. As court system, we do believe in redemption. We do believe that people can make change for good, but you know, that's something you're going to have to prove to yourself in the court. And Ms. Sinclair, good luck with the counseling. And once you both have completed it and provided that to Ms. Holly, you can address the issue of whether or not you should have contact. All right, thank you. Thank you. So, Ms. Underwood, I have Mr. Bomarito. He's been hanging out with me this morning, so we'll take care of him next.
Thank you, Your Honor, and thank you
You're
for
welcome.
your patience.
No, I told him you like the other judge better and you go to him first every day, so.
That's, Your Honor, your room wasn't made up, so I went to Judge Oldsaber's room, which was made up, but I did not go first.
Okay, all right, this is in the matter of the people of the state of Michigan versus Delshawn Leonard Bomarito, file number 25-22196FH. This is the date and time set for sentencing. I have Rhonda Underwood appearing on behalf of Mr. Bomarito. Let me find his PSI. No, I have it. There it is. Miss Underwood, I know sometimes it's hard to get into MDOC. Do you need a breakout room with Mr. Bomarito?
I do not, Your Honor.
All right, so Mr. Bomarito, have you had a chance to read and review the pre-sentence report?
Yes, I have.
Good. Have you had an opportunity to discuss that report with Ms. Underwood?
Yes, I have.
Are you satisfied with Ms. Underwood as your attorney and the advice that she has given you?
Yes, I am.
Good. Ms. Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
I don't think so, Your Honor.
Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
It does not, Your Honor.
The probation department computed the minimum sentencing guidelines to be 10 to 28 months. And of course, the court does agree to sentence him to the low end of the guidelines, which is 10 months.
That's
So,
correct, Your Honor. And we have no disagreement with the computation of the guidelines.
Okay. Before the court passes sentence, Mr. Bomarito, do you want to say anything on your own behalf?
No, I do not.
Okay.
Or
Ms.
I-
Underwood.
If I,
Oh, go ahead, Mr. Bomarito.
if I could say sorry to the officer that I assaulted, I would say that I'm sorry and I apologize for doing that.
Thank you. Thank you very much. Anything else?
That's it.
All right, Ms. Underwood, is there anything you'd like to say on behalf of Mr. Bomarito?
Just that Mr. Bomarito has expressed genuine remorse to me, Your Honor. He understands that his problems that day, he didn't need to visit on the outlet. Mr. Bomarito is in prison for a long time, Your Honor. He understands that. It's my hope that programming for Mr. Bomarito, I understand sometimes when people are in prison for a long stretch, Your Honor, they don't produce programming for them until it's like right before they're supposed to get out. It's my hope that Mr. Bomarito can get programming, Your Honor, and address issues maybe educationally if he's able and with his diagnosis, but just to ensure that Mr. Bomarito has the best chance for when he does get released, Your Honor. I believe Mr. Bomarito is sorry, and I believe the sentence that the court cobs to will be appropriate in this matter. Thank you, Your Honor.
Thank you. All right, in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. The sentence of the court that you will serve 10 months to 7 years, 6 months with the Michigan Department of Corrections. Because you're currently incarcerated, you don't get any credit for time served. There's a $130 crime victim rights fee and $68 in state costs. Now, Mr. Bomarito, you do have the right to appeal the sentence, and we are going to mail out to you your notice of right to appellate review. One copy is for you to initial and date and send back to us to acknowledge that you received the paperwork. The other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right, Mr. Bomarito?
Your Honor.
All right, thank you so much, Judge.
Mr. Moore?
Yeah, could we address the consecutive sentencing, please?
And it's consecutive to the current sentence you're serving now on homicide and felony firearm. Are you still serving the felony firearm, or are you done with that one now, Mr. Bomarito?
I'm done with that.
All right, so you're on the homicide one, so it's consecutive to that one, okay, Mr. Bomarito?
Okay, thank you, Your Honor.
Thank you, and you have a good day.
So, thank you,
Bye-bye.
Ms. Underwood.
Good luck, Mr. Bomarito.
All right.
So, Ms. Underwood, I'm sorry, Mr. Degemer wasn't, she got here before you did, I'm sorry. All right, so Miss Underwood, I do have Miss Lake. Look at my jail list. Yeah, Margaret's in jail.
I have Angelina Hall, Your Honor.
She's in jail.
Is she in jail? Good. Shows up that way when she's in jail. Hi, this is Judge Ann Sloan. So I am ready for Angelina Hall.
Angelina Hall?
Yes.
All right, I'll let it know.
All right, thank you.
Yes, ma'am.
Bye. And Mr. Degemer, your Mr. Oliveras and Ms. Smith are here in person, right?
I'm just on Mr. Oliveras.
Okay, you've already talked to him?
Yeah.
Okay.
Mr. Oliveras, please.
Okay. All right, Mr. Bomarito, I'm gonna send you on your way. You have a good day.
All right, thank you.
All right, so Kaylee Lake, why don't you go ahead and unmute your device, please?
Your Honor, did
All right,
you do appellate rights on Mr. Bomarito?
yeah.
Okay.
All right, Mr. Moore on Kaylee Lake. She pled to an attempted, did you have guidelines, Miss Underwood?
I was told that since it's a elevated misdemeanor, Your Honor, there are no guidelines.
Okay, all right, works for me. All right, Miss Lake, this is in the matter of the people of the state of Michigan versus Kaylee Dawn Lake. File number 25-22146FH. I have Rhonda Underwood appearing on behalf of Miss Lake. This is the date and time set for sentencing. Miss Lake, have you had an opportunity to read and review the pre-sentence report?
Yes, Your Honor, I have.
Have you had an opportunity to discuss the pre-sentence report with your attorney?
I do believe we have gone over it, yes.
Okay.
Your Honor, can I have just a brief breakout? Because it's not, I don't believe we have went over it.
Okay, that's fine. I can skip over to Mr. Degemer. So hold on, I'm going to open up a breakout room in Miss Lake. I'm going to put you and Miss Underwood into that breakout room. And when you're done, she'll come back. If you can't figure out how to come back, don't worry about it. I'll bring you back. All right. Okay, so do you want to go sit with your attorney? So this is in the matter of the people of the state of Michigan versus Castro Cash Oliveras. We have two files, 24-21891FH and 24-21892FC. I have Dave McCready appearing on behalf of the people, and I have Michael Degemer appearing on behalf of Mr. Oliveras. This is the date and time set for sentencing. Mr. Oliveras, have you had a chance to read and review the pre-sentence report?
Yes, I have.
Have you had an opportunity, Mr. Degemer in the microphone? Yeah. Mr. Degemer, have you had an opportunity to discuss it with Mr. Degemer?
Yes, I have.
Are you satisfied with him as your attorney and the advice that he has given you?
Yes, I'm satisfied.
All right, Mr. First, Mr. McCready, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
There are a couple of things, Your Honor. I've gone over these with Mr. Degemer. On the first page indicates that there's a plea agreement of home invasion third degree. In the body of the report, it's correct in second degree, but that should be changed.
Okay, so under the box where it says plea agreement, it's second degree, not third degree.
Correct.
Okay.
Second page. Again, under home invasion second degree, under the boxes. Again, the recommendation of 2 years to 15 years, that's fine. I just want to note that there's a Killebrew that covers both files. That is a 6-year to 15-year sentence. But more critically, the victim in that case.
Can we go by file number? So 24-21891 FH is a victim.
Correct. The victim on 891 FH is Juan Sanchez, not Troy Pasha.
Okay, hold on 1 second. And it's Juan Sanchez.
Correct.
All right, so we will strike Troy Pasha and put in Juan Sanchez. Is Troy Pasha the victim on the second one?
That is correct.
Oh, okay, got it. Thank you.
And there's one scoring error on the sentence information report. Do you want to cover that now or later?
Yeah, we're going over, are you talking about guidelines?
Yes.
Oh, we're not at guidelines yet. Okay, would you agree with all those changes that we've made, Mr. Dagomar-Gosian?
No objection.
All right. Do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Nothing in the body report.
All right. Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect, Mr. McCready?
No.
And Mr. Dagomar-Gosian?
None to my knowledge at this time.
All right. So now I'm gonna go back to the guidelines. And is it both guidelines or just one of them?
Just one, just the 892 FC case.
Okay, so the guidelines were computed, PRVs were 25, OBs were 50, and 108 to 180. So are you disputing a PRV or an OB?
OB.
Which one?
OB6.
OB6. OB6 is currently scored at 10. And what are you saying it should be properly scored at?
It should be 25. He's pled guilty to intent or no contest to assault with intent to murder. 25 points is scored when there's an intent to kill, non-premeditated intent to kill.
Do you oppose or agree?
Your Honor, based on the plea itself and based on the fact that there is a sentencing agreement, I don't have a challenge at this time.
Okay, so I'm going to change OB6 to 25, which will make the total OB 65. Does that change the?
It makes the OB level 4.
Okay, and what about the minimum range?
Range changes to 126 to 210.
And no position then, Mr. Dagomar-Gosian.
I agree with that change. That's changed.
Okay, thanks. All right. Okay, so all right, so we will make those changes before the court passes sentence. Mr. McCready, is there anyone here that wishes to speak as a victim?
I don't think so.
Okay, before the court passes sentence, is there anything you'd like to say on behalf of the people?
Just that we'd ask that Your Honor to follow the sentencing agreement that we've reached.
All right, and the sentencing agreement of 6 years to 15 years, that does fall within the sentencing range, so it would not be his guidelines.
Sorry. It is not, it is outside the guidelines for the home invasion, but I will indicate that he was initially charged with home invasion first, and it is within the guidelines for the home invasion first. He was getting the benefit of the bargain.
All right, and is that part of the plea and part of the bargain? So the people, you have no objection on any exceeding of the guidelines on that count?
On the departure, correct.
Okay, all right. All right, anything else you wish to say on behalf of the people?
Just that part of the agreement was that there was restitution as determined by the court, and I do know that there is restitution because the stabbing victim, Troy Pasha, has contacted us with his medical bills, but our victim services did ask him to bring those in, and he hasn't yet. So I don't know how the court wants to deal with that.
So we can leave restitution and be determined, but obviously he will have an opportunity to have a hearing on that restitution. Mr. Dagomar-Gosian, any objection to that?
No.
Because he would have a right to contest.
Okay.
All right, anything, Mr. Dagomar-Gosian, you'd like to say on behalf of your client?
Your Honor, I would just ask the court to follow the sentencing agreement. I will say that while the 6 years is outside of the newly calculated guidelines, it really and this is what I would have argued if this was litigated, is that that range does fall within what would have been a GBH sentence, and that's what I would have argued at trial. And so that's just sort of the nuts and bolts on how we got to that sentencing agreement. As always, when a person is charged with an offense, there's always kind of more to the story than just what's on the complaint sheet. In the stabbing incident, Mr. Olivares's infant was not directly involved, but Mr. Olivares was holding the child at the time of when there was this initial confrontation. And so the only reason I'm saying that is, again, there's always more to the story than just what is on the complaint. It doesn't excuse any conduct on Mr. Olivares' behalf, but I did just want to highlight that there was prior familiarity with the victims here. As far as the restitution, we can leave that to another day, but obviously nothing has been provided to the court or to people, so there's been not anything to address there. And then sort of moving to Mr. Olivares, I think the end sentence allows him, and I think he's young enough to, when he does get out of prison, to kind of turn this around and hopefully not be back in the criminal justice system. And I've talked with Mr. Olivares. He recognizes that obviously is the goal in life, and so I hope that after this sentence he will better. And again, he's young enough to make that decision for his own. So that's all I have. I don't know if he wants to address the court.
Mr. Olivares, is there anything you'd like to say on your own behalf?
No, there isn't, Your Honor, but I thank you for this opportunity to get a second chance at life.
I hope you do, because you're young, you're 22, so you're very young, you're 22 still, right?
Yeah.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offenses, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentences are the nature and gravity of the offenses, the discipline appropriate to its commission, deterrence against repetition by you and by others, potential for reformation, vindication for the law, and the protection of society. On file number 24-21891FH, sentence of the court that you will serve 6 years to 15 years with the Michigan Department of Corrections. You do have credit for 361 days already served. This hasn't been adjourned, right? No. During that term of probation or during that term of incarceration, you're not to have any verbal, written, electronic, or physical contact with Juan Sanchez directly or through another person. Once you're on parole, you can't be near the residence, school, or place of employment. There's a crime victim assessment fee in the amount of $130 and $68 in state costs. They probably will take that out of your money account at MDOC. So if your family pays that up front, then they won't do that. On file number 24-21892FC, it's a sentence of the court will serve 6 to 15 years with the Michigan Department of Corrections. You have 380 days credit on that file. You're not to have any contact with Troy Pasha, verbal, written, electronic, or physical, directly or through another person. Once you're on parole, you can't be within 500 feet of the residence, school, place of employment. $130 crime victim rights fee, $68 in state costs. Again, your family can pay that here, and that way it doesn't come out of your money at the MDOC. Restitution on that file will be to be determined. Once we receive that, you do have a right to have a hearing on it. And I believe you would still represent them on that as well, Mr. Deger-Margosian. And those sentences run concurrent, so they don't stack. You'll be eligible for parole when you're 28 years old, so you'll still be young. Mr. Olivares, there are services available within the Michigan Department of Corrections, educational, trade, whatever, your family's here. I'm assuming this is your family. I think you have support, and I think you can change this path. All right, so you do have the right to appeal these sentences. My bail is going to hand down to you what is called your notice of right to appellate review. You're going to initial one copy for each file for our records, just to acknowledge you received the paperwork. If you wish to appeal your sentence, you would fill out the information on the forms and mail them to the address listed on the form within 42 days. You can do that today, or you can do it once you get to MDOC. Is there anything I'm missing, Mr. Moore?
No, Your Honor. Thank you. Are those sentences concurrent with each other?
Yes, sir.
Thank you.
All right, record should reflect, I received back signed copies of the notice of right to appellate review. Good luck to you, Mr. Castro. For the family's benefit, he'll go to Jackson for like 30 days. Mr. Daggermark knows, he can probably explain it to you. All right, so Miss Underwood, we're back with Miss Lake. So Miss Lake, have you now had an opportunity to discuss the pre-sentence report with your attorney?
Yes, ma'am.
Are you satisfied with your attorney and the advice that she has given you?
Yes.
Ms. Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
We do not, Your Honor.
Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
It does not, Your Honor.
All right, and evidently there aren't guidelines, so
Your
we
Honor.
did not. Yes,
I'm sorry. I believe, can we turn off the YouTube, Your Honor?